My lord, not, I can say for on my behalf, not me.
Anyway, in a lighter vein, we have put the entire volume of Keshwanand and everything associated on the web page now. Because yesterday marked the
Yesterday, a lot of it, that by itself was a historical
so they
event.
didn't have to include it for justice for all of us. Who included the Keshwanand volume?
Lord, I'm not
the
very
petitioner.
certain, but
Anyway, so please take mark what Justice Bhatt has said, because you don't have to include this kind of thing for
It
us.
is impossible even if we create folders that the registry has
Dr. Guruswamy, it appears that you have included the entirety of the Keshwanand, the judgment.
I'm sorry, I didn't realize that, my
I
lords.
think, Dr. Guruswamy, let's not make assumptions about ignorance, because your entire volume, a major part of it is on the issue that the courts in India have the power of judicial review. So I think this could have been stated more clearly.
In
And
one sentence with a couple of footnotes.
and
My
then
lords, I apologize, my lords. I didn't know that these cases were uploaded. I'm very sorry.
Also, what happens is,
Apologize
you know,
to Justice Bhatt and
with
to
so
the-
much of data, it also burdens the system which we are all operating, you see. Because
unmanageable. You see, Dr. Guruswamy, your substituted written submissions run into 159 pages. One has to go over all the same things again and again.
No, my lords, it's
appreciate
mostly
that.
annexures which are domestic studies. There's no repetition, my lords.
Very well, but you see, this page.
what we would suggest is that, you know, cut down your written submissions to the core, because otherwise.
What I
Very
would
well.
suggest is, my lord, what, not for, on our side, my lord, that instead of, my lord, annexing judgments, if we rely upon one para, we can quote in our written submissions. So that, my lord, in one go, your lordships can read it, my lord. It might increase from 50 to 90, but it would easy.
And you know, the
Yes,
purpose,
my lord.
purpose of having a common compilation is that all the judgments which were going to be cited are included in that common compilation. But surely something like Keshwan Bharati, you don't have to include in the common
Yes,
compilation.
I apologize, my lords.
Because you'll be relying upon one para, which we
Very
can
good.
always
I'm
look
so
at
sorry.
from the, we can look at that paragraph from our law report.
Yes, and in any case, the relevant
But we'll
extracts
clarify
are
one
there. So
point.
I'm not
Sorry.
sure why it's.
Lord, what should we clarify? Because some courts want the whole judgment to be included. Well, what we do in Madras at least put the title page and that relevant paragraph.
Yes.
And also permission to highlight the passage.
Also, Mr. Datar, if the judgment is 30, 40, 50 pages, it doesn't matter. Because then it really doesn't burden the, because sometimes you want to read around, you want to read that.
Volumes, my lord,
No, my lord,
suppose.
what happens?
something
Suppose the
like
fact
Suppose
of
place Puttu Swami, my lord, it's
my
in.
lord, my lord, may I just cut this short because we are so time bound that
All right, let's get, anyway. just
we'll
first
be
main
burdened
point.
with your lordship.
Only one word, my lord, if your lordship doesn't.
Yes, one of the,
Protocol has to
one
be
of the-
set
on this
up.
side.
On ours.
But
I'm
we
appearing
just-
on this side.
One word, my lord.
Yes.
Protocol for allocation of time, all this has to be set down now. That's very important. My lord, this is a very good beginning, but let it be done properly.
All right.
We'll make some suggestions,
All right.
but let's not waste.
Ms.
Going
Gupta
by
now.
this, my lord, I think we may start tomorrow, my lord. That's,
They will take the whole of the day, I think.
therefore, my lord.
We've
that's-
sort of kept it till 4:05 just to make sure you start tomorrow.
Yes, Ms. Gupta.
So, my lord, just
Why don't you formulate and tell us basically what are the 3 or 4 points that you will be covering, so that I think then we'll have a good picture of how much we have to.
So, my lord, I've given a short written 3-page note on my submissions yesterday, along with the South African judgment. So basically, what I'm going to, my lord, address your lordship is with regard to the Foreign Marriage Act, which has only been referred to by Dr. Singhvi in with regard to notice. But it's an important secular act, so I want to refer to that. So I want to first refer to the 23rd Law Commission.
Clarify, your written submissions remain the same that was part of compilation one?
Yes.
At
Yes.
page 556 PD.
That's right.
The 3-page written
right.
submissions, basically.
Yes, my lord, the detailed submissions are on page 556, and the 3-page submission was given separately along with one judgment of the Constitutional Court of South Africa yesterday.
What date is that?
It's called a written note, so it's just a 3-page note
Yes.
saying what are the basic points that I will cover.
3-page वाला कहाँ है?
Okay.
Has my Lord Justice Kohli got that?
Written submission folder.
Yes, yes.
My Lord, it will be in the same folder as the written submissions.
Yes. So what are you going to argue, Ms.
So-
Dikshit, tell us?
So, my lord, the 23rd Law Commission report I'll refer to briefly, which was the precursor of the Foreign Marriage Act. Then the Foreign Marriage Act and the fact that it applies to one Indian citizen living abroad who will marry a foreign citizen and their rights which come under the Foreign Marriage Act. Then, my lord, after that, I want to refer to the Committee of Nations because that is what Section 17(3) of the Foreign Marriage Act talks about. Then, my lord, I will want to refer to 3 judgments. My lord, all the Indian judgments have been referred to by Mr. Rodki in detail. And the foreign judgments, Oberfell has already been referred to in detail in Nalsa, in Puthuswamy, in Navtej. Lord, I want to refer to 2 of those, the Yogakarta principles, and then, my lord, the read-in and the judicial interpretation, and how the Special Marriage Act and Foreign Marriage Act, both are actually, the Foreign Marriage Act is really an extension of the Special Marriage Act. So, my lord, that's briefly what I'm.
All right, why don't we follow your note now, that note which you gave this morning?
Yes,
Then
my
we
lord.
can pause and you can sort of explain. It's a very short 3-page note, so we can really explain that. That's the best. So let's start with the background.
Yes, my lord. So what is distinct about the petitioner number 1 and 2 herein is that they are the only persons who are legally and validly married in another country, that is the United States of America. They were married in Texas under the valid civil law, and they have a 4-month-old daughter. So, my lord, they had a relationship and a commitment to each other from 2012. They finally got married in 2017. So, they've had a 6-year marriage. And, my lord, it is grossly unjust that they are free and equal in other parts of the world, in the free democracies. But in India, the country of the birth of petitioner number 1, they are invisible and their rights are not recognized. My lord, concomitant with that, I want to bring out the fact that during COVID time, visas were granted to spouses of Indian citizens. But not being recognized, this person did not get, petitioner 2 did not get a visa. So while they are a family, while they are married couple in the US, they could not come to India during COVID times, otherwise they would have been eligible. So insofar as their marriage is concerned, it is neither recognized nor visible in India. What they had sought to do was get their marriage registered under the Foreign Marriage Act, and marriages can be solemnized and registered under the Foreign Marriage Act. May I take immediately the court to the 23rd Law Commission report, which is on PDF file.
You have filed it, we need not read it. You can just go through your submission on that.
So, my lord, the 23rd Law Commission report was a takeoff from the Special Marriage Act, which provided under 4E that two persons who were citizens of India living abroad, because my citizenship goes along with me wherever I may travel.
So
They were
basically, the Special Marriage Act applies when both parties are Indian citizens.
would apply, used
They're-
to apply.
Yes.
But then that clause was deleted, and the Foreign Marriage Act came in its place, saying even when one is a citizen, they dilated on the fact whether domicile should be included, other requirements should be included, came finally to this, that at least one party is an Indian citizen, they'll be able to get matrimonial relief. And it's an enabling provision. You can have a mode of marriage under the Foreign Marriage Act, secular act like the Special Marriage Act, and that's why we want that it has to be interpreted in a manner which would.
So the Foreign Marriage Act now stipulates that where at least one of the parties is an Indian citizen.
That's right. That is the only criteria, and I will read with some details 17.3 of the Foreign Marriage
Let's
Act.
see the Foreign Marriage Act.
So if you're
Brothers, brother Paul and brother Bhatt, you have the Foreign Marriage Act with you readily available?
It's available with us, Chief.
Yeah. Let's see the provisions. This is a relevant provision.
So, my lord, can I just take your lordship for a minute to the statement of objects and reasons?
Sure.
Uh, it basically says the following are the salient features of the bill. One, it provides for an enabling form of marriage more or less on the same lines as the Special Marriage Act. Two, it seeks to lay down certain rules in respect of capacity of parties, conditions of validity of marriage, and also provides for registration. Three, the provisions of the Special Marriage Act in regard to matrimonial reliefs are sought to be made applicable with suitable modification not only to marriages solemnized or registered under the proposed legislation, but also to other marriages solemnized abroad to which a citizen of India is a party. Now, my lord, if I may take your, my lords, to section 4.
Yes.
A marriage between parties, one of whom at least is a citizen of India, may be solemnized under this act by or before a marriage in a foreign country, if at the time of the marriage the following conditions are fulfilled, namely, and it says the conditions which are there under the Special Marriage Act. My lord, the interpretation of 4C would have to be read in. Now, Dr. Singhvi has already spoken about section 5, which is notice of intended marriage. And now, my lord, if I may take my lords to, and solemnize of marriage where no objection is made, 9. Now 11, my lord. Marriage not to be in contravention of local laws. The marriage officer may, for reason to be recorded in writing, refuse to solemnize a marriage under this act if the intended marriage is prohibited by any law in force in the foreign country where it is to be solemnized. Now, clearly, we are the only couple, as I said, who are the petitioners before this court, who are validly married according to local laws. And what a travesty it is of fairness, my lord, where we in a country which believes in the rule of law, which has a very robust system of fundamental rights, where this is the country of my citizenship and I'm being denied these rights. My lord, 17, my lord. Registration of foreign marriages. And these can be, so there can be solemnization under the act and there can be registration under the act. 17 is talking about registration under the act, para materia to the Special Marriage Act. A marriage officer is satisfied that a marriage has been duly solemnized in a foreign country in accordance with the law of that country between parties of whom one at least was a citizen of India. A party to the marriage informs the marriage officer in writing that he or she desires the marriage to be registered under this section. Now, my lord, we went to Washington to the marriage officer and we got no answer. Then we wrote an email and we were told, since you are a same-sex couple, therefore we are not registering your marriage. That's in my writ petition, which is 501.15. I'm not going to read it out. Then, my lord, 2, 17.2. No marriage shall be registered under this section unless at the time of registration it satisfies the conditions mentioned in 4. Now, my lord, comes the relevant part. The only ground on which they can refuse. The only ground on which they can refuse is the marriage officer may, for reasons to be recorded in writing, refuse to register marriage under this section on the ground that, in his opinion, the marriage is inconsistent with international law or the Committee of Nations. Today, 34 countries have accepted same-sex marriage. The country in which local law I have been married recognizes my marriage, and therefore the marriage is in accordance with international law. With regard to the Committee of Nations, my lord, my case is that it accords with the Committee of Nations, and India has always recognized, whether through Vishaka, whether through Alcon, whether through a host of judgments, that Committee of Nations principle will be respected by the
There are no conditions for marriage set out in this.
Section 4, my lord.
What are those
Section,
conditions?
Section 4, neither party has a spouse living, neither party is an idiot or a lunatic. The bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. But because it says under section 11 that marriage not to be in contravention of local laws, and my marriage was valid under the local laws in Texas in USA, the marriage is not in contravention. So, and it is in compliance also of section 4. So there are only two conditions. One, that it should be in accordance with international law. Second, it should be in,
It mentions about prohibited degrees. Where is the
yes,
prohibited degree?
yes, my lord.
Where is
Four proviso. No, 4D.
yes, but where do,
4D and 4 proviso.
where do we get what is prohibited degree of relationship?
2A, my lord. Degrees of prohibited 2A, my lord,
Special
degrees
marriage.
of
Special
prohibited relationship.
Basically, the FPA has been imported.
Yes. my lord. And the proviso makes an exception of 4D. Similar to SMA, my lord. Now just 27 and then
Proviso to section 4, which says that if personal law or custom governing at least one of the parties permits of a marriage between them.
that's,
So the personal law comes in here, right? If
that's
the personal law permits, and this is not special marriage. If the personal law, if one is let's say, of belonging to X religion, it personal law permits or does not permit. If the personal law of the other person permits it, then the marriage is possible.
No, notwithstanding that they are in a prohibited degree of relationship. So that is an exception
That
to
is
the personal.
So Chief Justice, that is also subject to custom, isn't it? For
Right, right. So what it says is where the
instance-
personal law or custom
Yes.
governs, permits the marriage between the parties, then even if they were otherwise within a prohibited degree of relationship under the Special Marriage Act, that marriage would be valid. That marriage can be registered.
So that is up to custom. Then we bring in custom there.
Right. Personal law or custom, both.
my lord, section 27. So the matrimonial reliefs, if I may just point out section 18, which I won't read, are in accordance with the Special Marriage Act. And my lord, all matrimonial judgments, because they deal with the status of parties, and therefore there is great importance, are judgments in rem under the Evidence Act. So great importance to my status. No one can just brush it under the carpet and say that, look, how does it matter? You can have a live-in relationship. The live-in relationship does not answer my status. And my status as a person who is married, who has rights under marriage, has to be recognized if I have to get true equality. My lord, section 27. Act not to affect validity of marriages outside it, Nothing in this act shall in any way affect the validity of a marriage solemnized in a foreign country otherwise than under this act. And my lord, 17 does a deeming provision under 17(6) that you are deemed to be married under this act. I failed to point that out. 17(6), a marriage registered under this section shall from the date of registration be deemed to have been solemnized under this act. So, my lord, as far as the Foreign Marriage Act is concerned and the scheme, my lord, that is what I wanted to refer to. Now, my lord, if your lordship may come to the next point that I wanted to speak about, which were the rights of citizens under the Foreign Marriage Act. So, as I said, my lord, the Foreign Marriage Act envisages marriages solemnized abroad would be recognized as long as they are within local laws of the country. They would be registered if they are in accordance with the international law and they are in accordance with the Committee of Nations. My rights as a citizen cannot be denied to me just because I'm living abroad. Look at the anomaly it creates. I am a married couple abroad. I have a family abroad. I come to India and then we become strangers in this country just because we have not interpreted or given full effect to our constitutional and fundamental rights under Part 3. So if same-sex and gender non-conforming couple marriages are excluded, my marriage becomes invisible. I, as an Indian citizen, will have my rights trampled upon. I come here, my spouse, petitioner number 2's in-laws are in Model Town in Delhi. It's so near home. And yet they cannot travel, they cannot be recognized. They become non-family, non-citizens. This cannot be, my lord. They cannot be non-married just because they are entering the soils of this country, which upholds fundamental rights.
All right, let's go to item 4 of your submission. You made the
Yes. So, my lord, item 4 is what? My lord, 4 is what I've just referred to, that discrimination on the ground of sex, sexual orientation, gender of my partner is violative of my inherent human rights. So, my lord, for this special reference would have to be to Article 50, discrimination on the ground of sex. So, discrimination happens on the ground of my sex, my partner's sex, my sexual orientation, my partner's sexual orientation. My lord, even if we don't emphasize on my freedom of expression, we don't of my right to life, my right of equality and marriage equality, the most fundamental is that it is discrimination on the ground of sex. Same way as in many parts of the world, women were not given right to vote only on the ground of sex. There is no distinction. There is no distinction. Sex and gender, sexual orientation, and your lordships have held that. My lord, may I just come to number 5, point number 5, my lord. I showed it. My lord, the concept of marriage and family. My lord, I want to re-emphasize, which I'm sure is there, that marriage is the oldest social institution. So while man is an individual, he has autonomy, he also is a social being. COVID times have shown that demonstrably how difficult we found to be living alone and in an island. So being a social person, this is the oldest social institution, and marriage is an expansive, evolutionary, inclusive concept. At one time, interracial marriages were not recognized in the US. In India, intercaste marriages were not recognized. So on, marriage has never been a static concept. It's a evolving concept. The moment that we have recognized that those of the LGBT plus community have rights, they may be a minority, but the majority cannot decide the rights of a minority. And my lord, when I say this, I just want to quote John Stuart Mill, which I did in the beginning of my note, if I may just say that, resound that with the quote: if all mankind minus one were of one opinion, and only one person or were of the contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would he be justified in silencing mankind. The tendency of society is normally to impose, by other means than civil penalties, its own ideas, practices as a rule of conduct on those who dissent from them, to fetter the development and, if possible, prevent the formation of any individuality not in harmony with its ways, and compel all characters to fashion themselves upon the model of its own. May I now turn back to the note, my lord, numbers at point 6.
6.
So, my lord, this is dealing with the Committee of Nations. When I read out section 17.3, I referred to this. May I just refer to Black's Law Dictionary, my lord? Committee in the legal sense is neither a matter of absolute obligation on the one hand, nor of mere courtesy and goodwill upon the other, but it is the recognition which one nation allows within its territory to the legislative, executive, or judicial acts of another nation, having due regard both to international duty and convenience, and the rights of its own citizens or of persons who are under the protection of its laws. My lord, the Yogyakarta principles have already been referred to. May I refer to, sorry. So, my lord, the Yogyakarta principles have been referred to in Navtej Singh Johar as well in his Nalsa. I'm only going to read para 563 of Johar, which is in my written submissions. I'll just read it out. However, the overwhelming weight of international opinion and the dramatic increase in the pace of recognition of fundamental rights for same-sex couples reflects a growing consensus towards sexual orientation equality. We feel inclined to concur with the accumulated wisdom reflected in these judgments, not to determine the meaning of the guarantees contained within the Indian Constitution, but to provide a sound and appreciable confirmation of our conclusion about these guarantees. My lord, may I start to the judgments, which are my point number 7, because so, my lord, what I am saying is constitutional committee. The fundamental rights require not just committee of nations. The word is constitutional committee. And at the risk of framing this, there has to be a constitutional committee. India cannot be lagging behind.
Now we'll go to your point number 7.
Yes, my lord. So, my lord, basically what I'm saying is 12 out of the G20 countries, including the European Union, have permitted same-sex and marriages, and about 34 countries of the world. But virtually every democratic, progressive country of the world has recognized same-sex marriages. We cannot be behind, even if it's one person, even if it's one minority. We cannot deny them their rights. And my lord, these rights,
Yes.
my lord, these rights include their rights of visas, of passports, of right to live in India, because they can't be made to shunt in and out as tourists. Rights of inheritance. Sorry. My lord,
Yes.
sorry. My lord, my rights of adoption, my rights to have children, whatever means permissible under law, my rights for insurance, my rights, every right flows actually out of this old institution, which is recognized and has been revered in our country. So we can't just wipe it clean by saying that it means nothing. Now, my lord, your lordships may just look at 3-4 judgments which I want to refer to, which are court-led recognition of same-sex marriages. Because the issue that was being raised was, should it be by the court, should it be by parliament? The constitutional duty is of these courts to uphold Part 3 of our constitution. And therefore, that interpretation has to be placed, which will bring this in. My lord, Oberfell and Forey have been read in part, and they are in the compilation. I may just take your lordship to the Austrian judgment, which is the Constitutional Court of Austria. It's page 1080 of the PDF file, volume 4 of the PDF file. First April. What little time. So, my lord, if I may take your lordship to 1080, this was a case, my lord, in Austria. They have 2 parallel legislations, one permitting marriages.
Which volume would this be?
Volume 4, my lord.
Yes.
4 in the judgment compilation.
Yes, we got it.
1080. Does Justice Call have it? My lord, just a minute.
What are you reading? The part of the judgment or the articles?
Judgment. My lord, just the judgments, Austrian, and then one South African judgment of 1999.
Okay, you read it. I'm listening. They'll take it out in the meantime.
Yes. My lord, just the prefix to the judgment, the facts. According to the applicable law, legislators had separated marriage between heterosexual couples and registered partnerships between same-sex couples, and had provided for different institutions for their relationships to be recognized by the state. So there were 2 exactly similar with all the same rights, except that there were 2 parallel institutions. One is a same-sex partnership and the other is a marriage. Now, my lord, if I may take, my lord, to PDF page. I think it's 1090, but it's 2.4. 1090. Lord, having given the background, 2.4.
2.41090.
This distinction between two legal institutions can no longer be upheld today without discriminating against same-sex couples with regard to their sexual orientation, due to the fact that, according to applicable law, legislators have separated marriage and registered partnerships as a consequence opposite sex and same-sex couples by providing for different institutions for their relationships to be recognized by the state, and even if the provisions governing these institutions have essentially the same legal consequences, it can be seen in a wide range of relationship arrangements that although registered partnership and marriages are comparable in terms of legal relations and legal consequences, those institutions still cover relationships that are basically unequal. Then 2.5.
So, Ms. Luthra,
Yes,
there was a separate body of law which permitted these civil relationships to be, registered. So
That's right.
there was a body of law like in England. In England also there were civil partnerships from 2004. Now this is that kind of a situation where there is an pre-existing statutory platform. Now what is not very clear is, when was this law enacted? Was it in 2009 or even earlier? Because it does refer to personal law, section 8, etc.
Yes, my lord. And I believe it was much earlier. I'll just answer your lordship.
No. Please turn to page 2, para 2,
My lord, 4.
at para 2, at page 1087 of the PDF.
Para 2.1 actually says that same-sex couples can enter into a registered partnership pursuant to the Registered Partnership Act.
That's right.
I just want to draw the attention of the court to the excerpt of the Federal Act on the Registered Partnership, Federal Law Gazette 2009. So this law was enacted apparently in 2009 and later amended in 2015. That is para 2.
Point one, yeah.
That's right. That's right, my lord.
Now
My
please,
lord,
proceed.
grateful, my lord. My lord, 2.6, I'm skipping 2.5 because of paucity of time. And so, my lord, 2.6, the distinction in the law between opposite sex and same-sex relationship as two different legal institutions thus violates the principle of equality, which forbids any discrimination of individual on the ground of personal characteristics such as their sexual orientation. So even the requirement to disclose that you will come under partnerships, even though you get the same gamut of rights, was itself considered to be discriminatory. My lord, going on 3.2.
But
fact-
so, Ms.
Yeah.
Luthra, even on issues such as adoption and medically assisted procreation, there are specific legislations in Austria. So, if you look at the bottom of page 1081, they say that recent developments in law allowed in particular joint parenthood also of same-sex couples. See in particular sections 191 and 197 of the General Civil Code, and use permitted forms of medically assisted procreation on an equal footing, namely Reproductive Medicine Act, Federal Law Gazette, 1992 as amended.
Yes, my lord.
In the next page.
So this is like two systems of law. See, this is let us understand the background. This is a civil law country where, keeping aside the considerations of personal law emanating from different parties' religions, we don't know how much of plurality exists in that society. Keeping aside that, this is more of an issue of classification, where they say that you cannot really treat them as separate classes. Now we are at a more fundamental stage. We have not legislated. So you want us to get into the second phase and say there is no classification. Yes, there is actually no classification as of now.
And basically what I'm asking is that even that was invidious of the equality interpretation. The fact that they had all the bundle of rights, whereas I have no right. I have no right. I want recognition of my marriage as an incident of 14, 15, 19, and 21. So the fact is, yes, we may be jump starting, but we are too late in the day. We have to come to that stage. We are already too late. India can't be lagging behind so much. Our jurisprudence is being seen all over the world. But here we are lagging behind the others. And we cannot deny our minorities, my lord. So your lordship is right that there were already two parallel institutions. But see how far they go, that even parallel institutions can't go. So in this case, what I'm saying is, I'm only asking there should be one institution. That's marriage. And I want that right.
Our citizens' rights are no less.
And my lord, what the court finally interpreted was, we are leaving both and let either side enter into either, so that even same-sex people can get into marriage, even heterosexuals can get into registered partnership. That's what the conclusion of the court was, which is so beautiful.
Just see para 2.6. That's what you are really arguing.
That's right, my lord. That's right. That's right.
Which is already less than any right we have. That's the better point, I think. Is this a right? Navtej guaranteed this to us.
And my lord, Navtej had actually started the footprints, and we have to now give effect to it. We cannot be left halfway. We cannot be left with our rights being
In
incoherent.
Austria, it appears that there were two different legal institutions created by law. Marriage for opposite sex heterosexual couples and a registered partnership for same-sex couples. So they said that this restriction, namely a registered partnership for same-sex couples, this is discriminatory. That seems to be the drift at page.
The walls, if I may say that, the wall separating the two was brought down.
Yeah.
Both kinds of both kind of relationships could go for either kind of relationship. Both type of couples, same sex and heterosexual couples, could go either for marriage or for civil relationships.
Yes, my lord. Yes, my lord.
Now see the result. The result, the relief which they grant gives us an idea of what was really the issue.
Yes,
The
my lord.
phrase of different sex in section 44 of the General Civil Code and the phrases of same-sex couples and of same sex in the Registered Partnership Act are therefore repealed as unconstitutional for violating the principle of equality.
That's right, my lord. And what it's saying, setting a deadline, whatever, the finding that earlier provisions shall not re-enter into force is based.
All right, I think,
We
thank you,
do-
Ms.
Yes.
Krishna. Now I think we'll wrap up at this, otherwise we'll.
My lord,
have to
now
the others
as
with
far
the
as
others.
this judgment is concerned, this is over. May I just take your.
There's a